Start. The legislature, in its wisdom, has itself placed the public servant on a different pedestal. Of proviso to section 200 of the Code of Criminal Procedure, object of holding an inquiry, investigation before taking cognizance in cases where the accused resides outside the territorial jurisdiction of such magistrate is to ensure that innocents are not harassed unnecessarily. By virtue of proviso to section 200 of the Code of Criminal Procedure, the magistrate, while taking cognizance, need not record statement of such public servant who has filed the complaint in discharge of his official duty. Further, by virtue of section 293 of Code of Criminal Procedure, report of the government specific expert is per se admissible in evidence. The Code of Criminal Procedure itself provides for exemption from examination of such witnesses when the complaint is filed by public servant. The appellant had filed a complaint under section 138 of the Negotiable Instruments Act 1881. On 26/6/2021, the judicial magistrate issued process on the complaint. The High Court held that as the respondent was having its office outside the jurisdiction of the magistrate, it was necessary for the magistrate to hold an inquiry under section 202 CRPC, and non-compliance with the mandate of section 202 CRPC vitiates the order issuing process. Therefore, the High Court set aside the order issuing process without issuing any further direction to the magistrate to hold an inquiry under section 202 CRPC. The Honorable Supreme Court referred to its Constitution Bench decision in the case of expeditious trial of cases under section 138 of the Negotiable Instruments Act 1881, 2021 SCC online SC 325, in which the Constitution Bench has directed as under. For the conduct of inquiry under section 202 of the Code, evidence of witnesses on behalf of the complainant shall be permitted to be taken on affidavit. In suitable cases, the magistrate can restrict the inquiry to examination of documents without insisting for examination of witnesses. The aforesaid decision, given in the background of a private complaint filed under section 138 of the Negotiable Instruments Act, cannot apply to the facts of the present case, where the complaint has been filed by public servant under the Benami Act. In Azim Premji versus State of UP 2024 SCC online ALL 1956, a coordinate bench of this court held that where the magistrate failed to ensure the compliance of section 202 CRPC, although the accused resides outside the jurisdiction of the court concerned, an inquiry on fact is mandatory before issuing a summoning order. However, this judgment does not take into consideration the provision contained in section 200 CRPC granting exemption to public servants, or the judgment of the Honorable Supreme Court in the case of India Limited within bracket Supra. In Divyajot Singh versus Manikaran Analytics Limited 2022 SCC online CAL 200, while dealing with a complaint filed by a person other than a public servant, the Calcutta High Court held that as the learned magistrate did not hold any inquiry under section 202 of CRPC, though the accused resided outside the jurisdiction of the court where the complaint has been lodged, and the magistrate merely held an inquiry under section 200 of CRPC, simpliciter, and only examined the complainant and no other witness or document, the summoning order was vitiated. This judgment also does not take into consideration the provision contained in section 200 CRPC granting exemption to public servants, or the judgment of the Honorable Supreme Court in the case of India Limited within bracket Supra. It is settled law that the inquiry under section 202 is of a limited nature. Firstly, to find out whether there is a prima facie case in issuing process against the person accused of the offence in the complaint, and secondly, to prevent the issue of process in the complaint which is either false or vexatious or intended only to harass such a person. At that stage, the evidence is not to be meticulously appreciated, as the limited purpose being of finding out whether or not there is sufficient ground for proceeding against the accused. The standard to be adopted by the magistrate in scrutinizing the evidence is also not the same as the one which is to be kept in view at that stage of framing charges. At the stage of inquiry under section 202 CRPC, the accused has no right to intervene, and that it is the duty of the magistrate while making an inquiry to elicit all facts, not merely with a view to protect the interests of an absent accused person, but also with a view to bring to book a person or persons against whom grave allegations are made. When we examine the impugned cognizance and summoning order dated 27/2/2024 in light of the law laid down in the above referred cases, it appears that the complaint has been filed by the Union of India through Deputy Commissioner of Income Tax Initiating Officer Benami Prohibition Unit, Kanpur. The special court has referred to the contents of the complaint that during a search and seizure operation conducted under section 132 of the Income Tax Act 1961, it transpired that a cash amount of rupees 30 lakh had been deposited in the account of MS Shyam Trading Company maintained with J&K Bank, Ghaziabad, and on 12/11/2016, and on the same date an amount of rupees 7,50,000 was transferred from that account through NEFT to the bank account of the applicant Ghanshyam Patel, proprietor of MS Shyam Trading Company, has denied ownership of the amount, and he stated that his account was misused by Rahul Chaudhary. The initiating officer, Benami Prohibition Unit, conducted an inquiry during which the applicant admitted that the amount deposited in the bank account of MS Shyam Trading Company was unaccounted cash, which was deposited during demonetization. After inquiry, the initiating officer found that the aforesaid property was Benami property, and he passed an attachment order under section 24 within bracket 4 of the Benami Act. The adjudicating authority gave an opportunity of hearing to the applicant, during which the applicant admitted on oath that the aforesaid sum of rupees 7,50,000 deposited into the bank account of MS Shyam Trading Company was the appellant's unaccounted cash, which was deposited during demonetization period and had been transferred to his bank account. Thereafter, the complaint was filed after obtaining sanction of Principal Director Income Tax Investigation before the special court having jurisdiction under the Act. Section 202 CRPC merely directs that the magistrate shall hold an inquiry, inquire into the case himself, or direct an investigation to be made by a police officer or by such other person as he thinks fit, for the purpose of deciding whether or not there is sufficient ground for proceeding. Section 202 CRPC does not prescribe the manner of holding an inquiry under this provision. The special court has passed the impugned order dated 27/2/2024 taking cognizance of the offence and summoning the applicant after taking into consideration the aforesaid facts and after recording satisfaction that from the averments made in the complaint and the documents filed with the complaint, there is sufficient ground for proceeding against the applicant.